All right, go ahead.
Welcome, everyone. Welcome, iSchool alumni and friends, and a special welcome to those from the School of Law. It's good to have everyone in the room. I wish we're all in a physical room so we could share ideas before and after this lecture. So we want to thank you for joining us for this third lecture in a four-part series with faculty and researchers from the Center for an Informed Public here at the University of Washington. This evening's talk will focus on the role of law, policy, and technology in countering the flow of misinformation. I'm looking forward to learning a bunch from it myself. I'm Jevin West. I'm an associate professor at the iSchool and the director of the Center for an Informed Public. For those who might not be familiar with the CIP, we're a new center that was launched in December of last year with the mission to resist strategic misinformation, promote an informed society, and strengthen democratic discourse. We're a nonpartisan and interdisciplinary center where we bring together a diverse set of voices from across industry, government, nonprofits, and other institutions to confront the spread of mis and disinformation through our research, education, community engagement efforts, and importantly, policy, which is going to be our topic tonight. As you might imagine, it's been a roller coaster of a ride this whole year, certainly with the pandemic, the recent and current election, I would say, social and racial justice efforts, and the many other things that are happening, all intertwined in those events. But I'm delighted here, in the midst of all that, to introduce the two speakers from today. Ryan Calo is a professor at the University of Washington School of Law and co-founder of the Center for an Informed Public. He's also a faculty co-director of the Tech Policy Lab, a unique interdisciplinary research unit that spans law, computer science, and information science. It's really one of a kind in the country and is really leading in this space. A well-known law and technology scholar, Ryan has testified before the German Parliament, the California Little Hoover Commission, and the full Judiciary and Commerce Committees of the United States Senate. And that happened just recently. Ryan also serves as an advisor to a wide range of organizations, including AI Now, the Center for Democracy and Technology, and the Electronic Frontier Foundation, and is a board member of the R Street Institute, which is part of the Knight Network. His areas of expertise include cyber law, privacy, robotics, and torts. Our other speaker for today, who will go second, Mary Fan, is also a professor at the University School of Law and a CIP faculty member. Her research and teaching are informed by her experience as a federal prosecutor and as an associate legal scholar at a United Nations criminal tribunal. Her expertise includes US and international criminal law and procedure, evidence, privacy, and immigration. She is the author of numerous articles and two books, Camera Power, Proof, Policing, Privacy, and Audiovisual Big Data, that was published by Cambridge University Press in 2019, and Perilous Science, Persistence and Survival in Politically Dangerous Research Domains. That was published by the Stanford University Press. And that's, well, it's forthcoming in 2020. Lots coming from Mary. So you're all in for a treat today as Ryan and Mary are leaders in the field. There will be time for questions at the end of the lecture. You can send your questions to the speakers using the link below. I hope I'm pointing in the right direction in the description on the YouTube page. And thank you again for joining us this evening, afternoon. I'll toss it over to Ryan. Take it away.
Okay, all right. Thank you very much, Jevin. Appreciate the generous introduction. And thank you everybody for participating in our community and being such great allies and supporters and alumni. So a lot of what I'm at the Center for an Informed Public with Jevin and some others, and a lot of what we do is we research misinformation, and we ask questions about, like, where is it coming from? How does misinformation travel? Where does it originate? Why do people respond to it the way that they do? And so a lot of it is just research into, like, information flows around misinformation and disinformation. But I'm a law professor, and Mary Fan, as you heard, Professor Fan's a law professor. And so I think less about the question of, information flows and that sort of thing. And I think more about who is responsible, right? I think about liability. That's what I think about all the time. As a torts professor and as a scholar, I think and write about liability, which is a question of like, who's responsible for the harms of misinformation and disinformation? And so an obvious culprit for these things is, of course, the speaker, him or her or themselves. That is to say, if somebody's telling lies, if there's lies out there, someone's telling them, right? And so, you look and you think about the individual as being potentially liable, or some organization that's working in a concerted way to pump out misinformation. But you know what? I'm actually going to leave that to the professionals. I'm going to leave that to Professor Fan, who has, dedicated her professional career to thinking about issues about liability, especially in the criminal context. And I'm going to focus a little bit more on our intermediaries, our platforms. So these are not the people that are doing the speaking exactly. These are the entities like a Facebook or a YouTube or a Twitter that people are speaking through. These are the places that we find misinformation and disinformation, and frankly, where disinformation and misinformation spreads and propagates. So when you think about responsibility of a platform, it gets a little complicated, and it actually gets quite complicated quite quickly. So if you imagine you're walking by a store, and in the window of the store, you see a Black Lives Matter sign. You're going to probably attribute that viewpoint to the store owner. If you walk past a bookstore and you see a book in the window that's about Karl Marx and how great Karl Marx is, for example, you might attribute that to the store owner. You might think, well, they're sympathetic. I mean, here they have highlighted this book about Karl Marx, but you know that that book was written by an author. When you go on Twitter, you don't expect it's Twitter speaking really at all. You think that people are using Twitter to speak. Now, Twitter is sometimes speaking, Twitter is sometimes privileging some speech over another, and so on. But the basic idea is that they're a mere intermediary, they're a conduit. So where would we locate liability then? Well, there's a couple places you could locate liability. One would be you could just say that, look, if bad stuff's appearing on your platform, Twitter or Facebook, you're responsible for it, right? So the idea would be you can get these folks in trouble, you can hold them liable, you can hold them morally responsible, because they have failed to clean up all the terrible vitriol, all the hate speech, all the lies that are on their platforms, okay? Another possibility would be that you'd get nervous about the fact that they were overdoing it, or that they were actually censoring people on the basis of that makes us feel uncomfortable. So you might think they'd be liable for letting a bunch of stuff thrive that was bad on their platform, or that they were selectively taking things down or elevating certain things that was in a way questionable. But the liability for this has been already determined years ago in a law, that a federal law that we're hearing more and more about. Used to be no one talked about this law, which is called Section 230, but now people talk about it all the time because the president has tweeted about it, and certain senators and others have made a sort of cottage industry about criticizing this law called 230. But it resolves our two liability questions in two important ways. First, Section 230 says we're not going to treat Twitter or Facebook or YouTube as the publisher of user-generated content, except for under very specific circumstances. We're not going to attribute these bad things, almost no matter how bad they are, to the platform. And so it says, look, you're immunized, Facebook, for the terrible things people post on Facebook. There are exceptions. Certain kinds of criminal laws, certain kinds of child trafficking and exploitation, copyright, certain things are carved out. But for the most part, you're immunized for what users do. And then Section 30 does another thing. And this is a law, from the Communications Code, Section 230 of the Communications Decency Act, and it's decades old at this point. And the second thing it does is it says, however, if you do clean up your platform and you take a bunch of stuff down that's terrible because it's hate speech or it's offensive or obnoxious or whatever it is, and you take things down in good faith, we're not going to let you be liable for censoring either. So 230 gives a lot of liability to these platforms, both for what users do and what Twitter and Facebook and the platforms do in response. And this, people think, has allowed the internet to thrive, but it's also created some concerns, and it's, for many, getting out of control. In fact, Section 230 and the liability we have today, which is very little for these platforms, has come under fire from two different camps. Okay, so one camp says that companies are not doing enough to protect the vulnerable online. These folks, usually from the left, these are progressives often, and they say, who is bearing the brunt of hate speech? Who is getting bullied and badgered off of these platforms? Who is getting targeted for misinformation and disinformation? Well, it's these vulnerable communities: people of color, women, people who are trans people. All kinds of populations that are vulnerable those are the folks who are getting targeted, and these companies are not doing enough to protect them, and they're hiding behind Section 230. But 230 is also getting simultaneously attacked typically from the right, from conservatives, who are arguing, actually, these platforms seem to have an agenda, and they seem only to be quibbling with misinformation statements if they come from certain sources, certain conservative sources. They seem to be picking winners and losers and privileging this content and dismissing this other. And so we're really worried about the fact that they're censoring everybody, So 230 gets two different sets of critiques. So let's look at those critiques in turn. Are companies doing enough? My own personal view is they're not. And I'll tell you, that has become so vivid for me living through coronavirus and this election. Because what it's shown is that when the companies want to amp it up and they want to protect people, they are able to do it. So whereas 1,000 flowers, 1,000 viewpoints, I'm not really flowers, but Venus flytraps and all kinds of other bad plants out there too. But they've allowed a lot of proliferation of content in the past, haven't labeled it as bad, haven't taken it down. All of a sudden, people start lying about coronavirus, and understandably, because people's lives are at stake, they start labeling aggressively and taking down misinformation about coronavirus. They also started doing about the election. They don't necessarily take things down, but they label it as disputed and not right. So what you see is that the platforms, if they're motivated enough, will be aggressive about it. We've also seen that in categories that were outside of Section 230 protection to begin with, like copyright, where these companies have had to come up with tools and aggressive strategies in order to take copyrighted material down off their platform, lest they have liability. Okay, maybe we could do something more about that. What about the possibility that companies are peddling ideology? Well, I don't know that I've seen a lot of evidence of that, right? I mean, so if you, for example, if you look at Facebook and you look at the top 10 most shared items, very often, many, if not most of those items are from conservative sources. I mean, certain sources seem to be flourishing on Facebook, and then it doesn't seem to be mapping onto ideology. If it acts onto ideology, it is in fact a right ideology. But also you have to say, not so fast. What if they were? Whether you think that they are or not, what if they were? What if they were putting their hand on the scale and privileging some messages and not others out of ideology? Okay, so I want you to consider, for example, that Verizon in 2007 got in trouble for rejecting a pro-choice organization, NARAL, from sending messages over its platform because it thought they were controversial in some way. And that bothered a lot of people that Verizon was doing that. Similarly, in September, so last month of this year, 13 years later, we see Zoom refusing to host certain kinds of events. For example, one featuring a Palestinian activist, and Zoom has said that they won't host an event by this person because they believe that her organization is somehow fomenting strife. So we might get concerned about that, the idea that these folks could put their thumb on the scale. So what do we do if we're concerned is a question that's interesting. So one of them would be like to repeal and start over. And some people think that we should just repeal 230, get rid of it, start over. I personally think that's quite dangerous. I think that 230 has permitted so much to flourish on the internet, and that it would be a bad idea just to get rid of it, and it really would fundamentally alter the way that a free and open internet works. Okay, Another is if you're worried about that first problem, that sort of progressive problem, you could condition immunity on providers taking reasonable steps to prevent or address third-party content that was problematic. This is a proposal by Danielle Keith-Citrin and Benjamin Wittes, where they just say, look, let's be reasonable about this. As long as the companies are trying hard, doing reasonable things to take down the bad stuff, then we should continue to immunize them. If you're worried about the fact that they're putting a hand on the scale, then things get really interesting and dicey. And so I'm going to end by talking a bit about what do you do if you think that Google is like privileging progressive content, for example, or you worry about Zoom picking and choosing who can have events on their platform, right? There you run into a couple of problems. So technically speaking, 230, which again immunizes companies for taking content down, just as it immunizes them for leaving it up. It says that the efforts have to be good faith. Okay, as long as you're doing good faith censoring, then it's okay. And you know, that good faith has come under a lot of sort of scrutiny and pressure, which it never had before. Most people thought that good faith just meant like you can't be anti-competitive. You can't like take down your competitor's stuff because it's antitrust. Not that you would be working in ideological good faith or sort of giving fair airing. And so a lot of pressure is being put on that right now. But you know, it's important to remember that platforms are not the government. And so platforms are not subject to the First Amendment. They're not subject to the free speech doctrine, but they are protected by it. And so the concern becomes, if you force a company to leave things on its platform, if you force a bookstore to leave a book in its display window, because otherwise it's somehow picking winners and losers, you begin to implicate the rights of that platform. You begin to, we get into a world of potentially compelled or coerced speech where the government is saying, you have to leave that on your platform. Leave that on your platform. And there the First Amendment analysis gets very, very interesting. Nonetheless, there are going to be attempts. There are going to be attempts to revisit the conditions under which platforms censor content, take content down. And one such effort, which I will just mention in passing, is that the Federal Communications Commission under Chairman Pai has decided that it's going to use its authority to look at the act, the Communications Act, where technically Section 230 lives, and it's going to see whether the agency can give us some better interpretation of what good faith might mean in response to these largely conservative concerns about the possibility of censoring. So you know, we'll see. We'll see if that continues under a Biden administration. We'll see if it gets anywhere. We'll see if courts stand up and say, look, no, you know, you can't tell Facebook to leave up something it disagrees with. You have to let it take it down, even if it's for ideology. But that's going to be concerning to some people too. So there's no easy answers. Anyway, these are the kinds of things that the center looks at when we look at law and policy. But I'm going to turn it over now to my colleague, Professor Fan, who focuses specifically on, even if you weren't talking about the platform, you're not talking about the intermediary, not the bookstore, you're talking about the author, him or herself, or themselves. You know, how do can we even go after that potential individual? So I'm going to sit back and be very excited to hear what Professor Fan has to say, but thank you again for your attention, and I look forward to any questions.
Okay, well, thanks so much for that that introduction and excellent overview over intermediary liability. Thanks to Professor Jevin West for his important work directing and founding the Center for an Informed Public, and Julia Scanlon, Tara Warman, and Putri Hiandarto for bringing us together today. So I'm going to talk about three main avenues to punish misinformation and constitutional limits on punishing misinformation. And I'm going to conclude by suggesting some reasons why we should advance beyond this punitive impulse, the allure of criminalizing as a strategy. Now, there are potential civil tort actions for deceit, fraud, misrepresentation. But because I am a former prosecutor and a criminal law and procedure professor, I will focus on the demand to punish misinformation. And you can direct your torts and civil law questions to my brilliant colleague and torts professor, Professor Ryan Calo. So let's begin here. So some jurisdictions like Mexico and the United Kingdom have aggressively prosecuted people for their social media posts. For example, controversy arose in Mexico over the prosecution of two people who live in the eastern state of Veracruz. They were charged with terrorism for their Twitter posts. One of the individuals, a 48-year-old teacher, tweeted, "I can confirm that at this particular school district, 5 children have been taken away by an armed group, total psychosis in the area." And he said that he had received confirmation of these kidnappings from his sister-in-law, whose kids attended the school. The second individual was a former government official who allegedly wrote that a helicopter had opened fire at another school while the children were on their break. And her Facebook post said this was confirmed and corroborated. Now, none of these events turned out to be true. There were no kidnappings, no shootout, and panic ensued in the streets of Veracruz. And the authorities say the pair were responsible for it. They say, look, more than 20 car accidents happened amid the hysteria. People left their cars in the middle of the street and they ran over to pick up their kids from the school because they thought these things were actually happening. So he vowed to prosecute them and indeed brought charges, leading to a movement, as you see in the visual here. Yo también soy terrorista, is this notion of like, wait, it's so broad, that a lot of people can be caught up with in this. In England, people have been prosecuted also for trying to, for example, incite riots on social media, among other things. Now, let's talk about the United States. Let's talk about here. In the United States, we have some of the strongest protections for free speech in the world. But this protection is not absolute. Famously, Justice Holmes wrote, "The most stringent protection of free speech would not protect a man from falsely shouting fire in a theater and causing a panic." Now, Justice Holmes's clear and present danger standard for criminalizing speech, enunciated in this long ago case called Schenck v. United States, it got tightened, it got constrained more in this other case, also very famous, called Brandenburg v. Ohio in 1969. And Brandenburg held that the constitutional guarantees of free speech and free press do not permit a state to forbid or prescribe advocacy of the use of force or advocacy of a law violation, except where such advocacy is directed to inciting or producing imminent lawless action and is likely to incite or produce such action. I actually helped pay my way and save up for law school by working as a journalist. And I remember in my media law class, they made us memorize that standard, that famous incitement standard. The Supreme Court also held another famous case called Chaplinsky v. State of New Hampshire, that legislatures may use narrowly drawn, limited statutes to define and punish the use in a public place of words that are likely to cause a breach of the peace, called fighting words doctrine. And then just to give you, I can't give you all the First Amendment law in 3 minutes, but I'll just give you a little bit of the relevant law. And there's another famous case called Watts v. United States. The Supreme Court held, while true threats may be criminalized, political hyperbole, caustic, vehement attacks, like we often see these days, may not. And of course, when we're talking about criminalizing misinformation, we have to talk about the Supreme Court's 2012 decision in United States v. Alvarez. The plurality opinion in Alvarez held that criminal laws punishing false statements are subject to exacting scrutiny. The court explained, some false statements are inevitable if there is to be open, vigorous expression of views in public and private conversation. Expression that the First Amendment seeks to guarantee. Now, the Alvarez court observed that content-based restrictions on speech have been permitted as a general matter only when confined to a few historic and traditional categories. Advocacy, first, the Brandenburg thing, advocacy intended and likely to incite imminent unlawful action. Second, obscenity. Third, defamation. Fourth, the so-called fighting words that I told you about. Fifth, child pornography. Six, very familiar to us as prosecutors, fraud. Seven, true threats from the Watts case I told you about. And eight, this catch-all for speech presenting some grave and imminent threat the government has the power to prevent. Although the court noted a restriction under this last catch-all is most difficult to sustain under the First Amendment. So Alvarez struck down a federal statute criminalizing falsely claiming to have received a military medal called the Stolen Valor Act. Now, after Alvarez, that act was revised. Congress took a clue from the decision, and you see on your screen here how Congress revised it. Take a look at the strikeouts and the additions. What do they make it look like? They made it look cognizable because they made it look like a more traditional fraud crime, basically based on fraud, for example, to obtain money, property, or other tangible benefit. We know that kind of language very well from fraud prosecutions. Now, let's get into criminalization then. Now, there are on the books in many states laws that criminalize the false spreading of public alarm. Most states have some sort of false reporting statute. Some are narrower. For example, they might just cover false fire alarms, false calls to 911, a false report given to law enforcement or other officials, things like that. Others, such as some examples that I've excerpted here out of New Jersey and New York, are actually broader, with the New York law that I've excerpted here and highlighted for you being among the broadest. Now, these false reporting statutes tend to be patterned after or influenced by the American Law Institute Model Penal Code provision that proposed criminalizing spreading or creating false public alarm. That Model Penal Code provision stated a person is guilty of a misdemeanor if he incites or circulates a report or warning of an impending bombing or other crime or catastrophe, knowing that the report or warning is false or baseless, and that it is likely to cause evacuation of a building or other place, public place, or to cause public inconvenience or alarm. Now, the Model Penal Code provision updated and codified a range of older offenses against public order. These public order offenses usually they affect a large number of defendants, involve a great proportion of public activity, and included things like false fire alarms, false reports of crime, false warnings of bombs, and so forth. Now, typically, these modern public alarm laws impose an intent requirement with respect to the veracity of the report or the lack of veracity of the report. Specifically, in the words of the Model Penal Code's commentary, the provision requires that the actor initiate or circulate a report or warning known by him to be false. That's a mens rea standard, we call it in criminal law. You have to prove that knowledge. This keeps, the Model Penal Code commentary explains, this keeps us from criminalizing that individual who merely repeats a rumor or otherwise circulates information that the individual doesn't actually know to be baseless. Second, the intent requirement also tends to apply to the ensuing harm. That is to say, the actor has to know that that conduct, that circulation of false information, was likely to cause public inconvenience or alarm. And this, of course, excludes from liability the practical joker or other, idiot who circulates a false alarm in circumstances where he is unaware of the potential for serious consequences. And we have a more narrow version in our Washington Penal Code for communicating or repeating any information concerning a threatened bombing or injury, knowing this information to be false, and with intent to alarm the person or persons to whom the information is communicated or repeated. Now, criminalizing what annoys us can be an alluring thing. We have seen in recent years the rise of some new forms of statutes to tackle misinformation that might injure, harm, or subvert people's rights. I've just given you one example here. It's California's new law making it a misdemeanor to spread misinformation about voting, a very timely thing, obviously, this year. It's in the Elections Code in California, and it makes it a misdemeanor to, with actual knowledge and intent to deceive, cause it to be distributed by a variety of means for our purposes, electronic means being one of them, information that, for example, misleads people about where to put their ballots, or whether they're qualified to vote, or when the election is or can occur, etc. The bottom line, of course, is it's trying to criminalize the use of misinformation to aid and abet the subversion of our right to vote. And I want to pause on this for a second and maybe part with some cautionary words about this impulse to criminalize. First, obviously, be attentive to First Amendment limits, because again, the court, and I think rightly so, has indicated that, you're going to have some spillage of hyperbole, messiness, potential falsity in robust, freewheeling debate. And let's be real. If I agree with you, I think you're telling the truth. If I disagree with you, I think you're a liar. So one person's liar could be another person's, speaking truth to power. So, there's going to be slippage here. And we have to be attentive to the First Amendment limits to protect space in a democracy for a robust, freewheeling, messy debate. Second, relatedly, criminalization makes more sense where a false statement causes harm or obstruction of rights. Nudging, these crude, overbroad criminalization of spreading misinformation towards looking more like a traditional crime, it may look stodgy and old-fashioned, like, why can't you expand your horizons and your perspective of what can be a crime? But actually, we're doing that because we're keeping the zone of the criminal, which is where the heaviest artillery of the state is. We're keeping the zone of the criminal to things that look like crimes that actually cause harm or lead to obstruction of rights. I guess I'll just say a final caution, which is, be attentive. When we say, I want to criminalize X because I really disagree and I think they're really hurting people, be it so, and I want a law in the books, be attentive to the reality of who actually gets prosecuted under these laws. It may not be the entities, the powerful, usually entities or persons, the savvy ones that have the ability to viralize the spread of misinformation. It may not be the ones you have in mind. It may be, for example, juveniles or a sophomore being, a juvenile or a sophomore. And kids post ridiculous, dumb, awful things. Their brains are not developed. And unfortunately, they have at their fingertips an ability to show the world how undeveloped their brains are. But does that mean that their mistakes should be criminal? Consider, for example, this juvenile. This juvenile here, I'm just giving you a citation to a case where a conviction was affirmed. And this was a case of a high school sophomore who obviously posted things in terrible taste. This is after the Sandy Hook shootings. And he posted, kids were shot, who cares? Dead kids are dead kids. Murder's a good thing. This is a serious status. I really think murder is a good thing. And, on and on and on about, I would have done this job myself if I could have. And when somebody said, man, this is a really bad post, he actually threatened, I guess perhaps jokingly, to get him too. There's a dispute of fact as to whether it was a joke. The two kids apparently knew each other and were gamers and killed each other in video games, etc. Bottom line, he's prosecuted for inducing panic and aggravated menacing. Aggravated menacing is for what he did, the threats to the other kid. Let's focus on the inducing panic, because this is an example of a prosecution under these widespread public panic laws I just told you about. He was prosecuted under this Ohio statute that I've excerpted here for you, basically similar to what I've described to you, basically prosecutions for causing serious public inconvenience or alarm based on circulations of knowing a report or warning is false. Now, the Ohio Court of Appeals upheld his conviction, saying, what he did was really annoying. He really scared and freaked people out. This is right after a shooting. A lot of parents pulled their kids from school. School administrators had to do all sorts of things to deal with this mess that he caused. So conviction affirmed. Think about what your kid might post, what you yourself might post, and ask yourself, you know, is this the subject of criminal law, or is there some other alternative to criminalization, like Twitter's innovative labeling or other public education methods, like the public education campaign that this center, for example, is doing with its various talks and series. Because look, punishing people doesn't make the gullible smarter. It's better to tackle the problem at its source, that market demand for misleading information that strokes our confirmation biases. It's better to educate and teach a person to be a better consumer of information than to have a couple of lightning strikes. And this is like how frequently these prosecutions occur, given the First Amendment constraints, to have a couple of lightning strikes for some cases that have annoyed or concerned some community somewhere. I'm going to pause here because my time is up. It's exactly 4:35, so we plan to speak for about 15 minutes and stop right here and take questions. And so happy to do so.
Great. Mary, can we take down your screen sharing for
Absolutely.
that way I can see both of us. Okay, so I see a question that looks like it's for me. Before I read it out and answer it, I just want to remind everybody, if you're live streaming, there's a link below the channel where you can submit questions, and they will hopefully make their way to us in where we are in our Zoom. Okay, so the question I got was, Ryan, you mentioned discussion. Oh, and by the way, Mary, that was like fascinating. I didn't know a lot of that. I knew the First Amendment stuff, but I did not know that there were actually prosecutions abroad in the United States, that there were new laws on the books. I'm so glad that you're working with the center and that you gave this talk. Okay, so you mentioned discussion of repealing 230. Could you project some possible outcomes of actually doing so? Some political figures seem to think it would just remove the tags Twitter currently has in place, and it wouldn't probably have more complex consequences. Gosh, that's an excellent question. What I would say is this. There is recognition on both sides of the aisle that 230 has not aged perfectly. Okay, and so like I said before, there's some set of people that think it's not protective enough, and another set of people that think that it gives too much of a free hand to platforms in order to engage in what amounts to censorship, right? You know, the way that 230 has been reformed in the past, or attempted to be reformed, has been by sort of shooting holes in it. And so adding exception, for example, there is an exception called fosta sesta that has to do with federal and state sex trafficking laws. And there has been a new proposal called Earn It that would also try to shoot more holes in 230. And so that the idea has been not that we're going to completely repeal it, but that we're going to it's going to riddle it with exceptions that a lot of groups that I'm affiliated with or not feel is problematic. The thing I think is really interesting to watch is this Federal Communications Commission rulemaking. If under a Biden administration, the Federal Communications Commission goes on to interpret Section 230, and specifically the Good Samaritan Clause, which says that good faith efforts to censor, and if are immune, if that happens, that will be really a place to watch, because what it would cause is it would really give, if good faith is interpreted in an aggressive way, then platforms would have next to no incentive. They would step back and have next to no incentive to police the internet. And so it would get worse for those people who believe that the main thing is protecting the vulnerable. Okay. Conversely, of course, if we did adopt something like a threat to 230 immunity, where if you're not taking adequate steps to take things down, right, then even at the margins, even if it's reasonable, that could lead to a lot of people, a lot of platforms deciding to over police and just not take the risk and just take things down just because they just don't want to get in trouble. And so what the truth about 230 is, small tweaks could make a really big difference in the ecosystem. And so while I don't necessarily know what reforms on the table, and it's been incremental so far, and people are not on the same page as to what reform has to happen, any change to 230, even if it were small or look small, could have an outsized impact on speech in America, is the honest truth. Mary, I think the next question is for you. I'm not sure if you see the chat.
I am looking at the chat on my screen, and it just has that one question you answered.
Let me read it to you, because I think maybe you're in a different chat. Okay, so the second question is, Mary, I'm going to ask you a question, Mary, but from people who are watching. You talked about intent. How does the law appreciate the difference between misinformation and disinformation? Should the law distinguish between the two notions, and on what criteria? And I'll add a tiny bit of gloss, as the way we talk about this internally amongst ourselves about misinformation versus disinformation for the audience is that misinformation is innocent. It's like you just are misinformed. You're just propagating things that you don't know to be wrong. Disinformation is, saying things on purpose in order to mislead people.
I think, that's a really interesting question in terms of the future of criminalization, if you wanted to go that avenue for dealing with disinformation, that distinction between the innocent misinformation versus the concerted campaign of disinformation. I will tell you right now that the law is, they're patterned after a model penal code provision enacted in 1960, or proposed in 1962. So we're not very sophisticated, and we're not usually on the cutting edge in the criminal law world. We tend to look at old paradigms. And so we don't have right now in our criminal law models, a sophisticated differentiation between dis and misinformation embedded in this notion of intent, which is a very old kind of thing. It's just, intent, we often think of it from a very individual perspective. Did you intend to spread this information? Whatever your personal reason is, you wanted attention, you wanted viralization, you wanted more likes, you wanted more followers, whatever. We don't distinguish. Intent is not this old, very common notion of intent is not the entryway into making more sophisticated distinctions between concerted campaigns of disinformation versus misinformation. Now, you could actually, in more sophisticated ways, design statutes that incorporate this notion of a systemic effort for some enumerated purpose.
Just can you just expand on that to the extent that do you mean like RICO or conspiracy or something? I mean, what would be a way for you to capture a disinformation campaign, right, which is full of lies and truth, and that had some bad goal? Is there a way to do that?
Well, I think you can kind of sense my views about criminalization. I think it's serious before it becomes criminalized. And so I would not criminalize a so-called campaign, because one person's disinformation campaign is another person's truth campaign. And in a democracy, you have to have room. I mean, your perception would be different than mine. That being said, if there is a concerted campaign that leads to a material harm, then you could actually, and I don't think you would try to cram it into RICO per se. I think, you would have to actually, rather than cram it into old paradigms for like prosecuting mobsters, I would actually, actually have a paradigm for what we're really concerned about, which is, systematic spread of misinformation for the goal, with the purpose. We often use like with the purpose, with a specific intent to, for example, manipulate prices for drugs, because I'm saying that take bleach, and it'll make you better, and or take whatever that I have stock in, so we would put some sort of specific intent element that captures the end goal of this disinformation campaign, rather than defining this amorphous concept of what a disinformation campaign is. Certain prohibited goals that are harms, basically.
Intent is so hard. Especially because it seems like a lot of purveyors of disinformation and misinformation are just trying to sell things, usually like vitamin supplements. Do you know what I mean? And there's this like weird correlation between purveyors of disinformation, like known purveyors of disinformation, who have a lot of traffic on their sites and happen also to be selling like things like vitamin supplements that we might be worried about. Okay, so we have a question I think probably is for both of us, but I'll read it out loud. We've got some questions about harassment. would the legal definition of harm include mental or emotional harm? And what about threats of violence? For example, Bannon's recent tweet about Dr. Fauci. And so I will just say that as a torts professor, tort law is more reticent to compensate purely emotional harms, and often will require either that the conduct be outrageous that led to the harm, and also that the harm be severe, and may even require a physical manifestation of the harm before you can recover. And it's almost under no conditions, at least in tort law, can you recover from somebody accidentally causing you just emotional harm. It's got to be really intentional. But in that case, we have something called intentional infliction of emotional distress. And some of the things you see online, could amount to that. But I'll turn over the threats of violence and Bannon's tweet about Fauci to Professor Fan.
Okay, so first I'll talk about online bullying and harassment. Actually, Washington State is actually one of the more toward the forefront of things like addressing cyber bullying and cyber stalking, for example. And so, for example, we have laws on the books here in the state that talk about intent to harass, intimidate, torment, or embarrass. And what's interesting is that that intent is defined quite broadly and may well capture some of your concern, the harm that includes mental or emotional harm, because think about like intent to embarrass, for example, as a form of cyber stalking. So yes, the legal definition of harm can actually be expanded to include mental or emotional harm. Now, with respect to threats of violence, that's actually an easier case, right? Because there you have a harm. There you actually may, well, I mean, it depends on the context, etc. But you may actually have a true threat, or you may actually have incitement of others to engage in that activity. Now, you're going to have to prove on the facts and circumstances of that case that it's not just, again, caustic political hyperbole, as the Watts court put it in their true threat case, that it's not just, being nasty, as we often see, but that it actually is a true threat or a true incitement of violence.
Yeah, I mean, that's the Bannon tweet about Dr. Fauci that got Bannon tossed from Twitter was basically something like the president should put that guy's head on a spike or something like that. You know what I mean? And so it was violent in its imagery, and enough for Twitter to say enough is enough. But no one believes that. I don't think anyone believed that Bannon really thought anybody should harm him physically, Dr. Fauci physically. That said, we also have situations where, like, a lot of sort of vitriolic talk leads to a criminal plot to kidnap, the governor of Michigan. You know what I mean? And so, like, what do you do about situations where people, like, there was a famous case years ago where a couple went on a shooting spree, and when they were caught, they said, "We never would have done this if it weren't for watching that movie Natural Born Killers." You know what I mean? And so the question was whether it was liability for these folks who say they never would have done this had they not been inspired by this movie that arguably glorifies violence. You know what I mean? Can you have liability for inspiring violence rather than inciting it?
No, I don't think you can.
And it turns out not. Yeah, it turns out not.
Are you gonna penalize like junk food manufacturers for making us fat?
Right. I thought you'd be skeptical.
You know what I mean? Like,
yeah.
Unfortunately, people are gonna binge on whatever junk diet they want, and that doesn't mean the producers of the junk food, whether it be junk information or junk food, are actually criminally liable. Now, will you have there been attempts to like get civil liability, for like producers of cigarettes or producers of junk food, etc.? I'm more agnostic towards civil and tort liability, but I think, criminal, we have a tendency to want to send a message and criminalize things. And I think, unfortunately, when you criminalize things, the people that get caught up in the actual prosecution is not who you're envisioning.
All right, so I have a question for you that I'm going to sneak in here, Mary, because you said, Professor Fan, you said something really interesting, which was, maybe we need better consumers of information, maybe more discerning people rather than criminalizing conduct, right? But what that made me think of was, what about when it's a foreign adversary? In other words, like one of the complaints I hear a lot is that under the Trump administration, the intelligence and military community has not done enough to disincentivize state actors, by making it uncomfortable for state actors to engage in disinformation campaigns and that kind of thing. So if the context is national security, and you're using diplomacy and economic sanctions and the like in order to pressure people to stop, do you think about that a little differently than you would, a kid who's saying disgusting but ultimately childish things about violence in schools?
So the distinction is in the national security context.
Yeah, neither of us, I suppose, are necessarily national security experts, but I guess what I'm trying to say is that sometimes I think about these things differently. I agree. I mean, speaking of protecting the marginalized, as you point out, it's often the marginalized who end up getting prosecuted under these laws. It's often like interracial couples where you see prosecution for sexting. Do you know what I mean? And because of like, he'll be like 18 and she'll be like 17 and somehow, you know what I mean? It's just like, you see things like that are disturbing. I feel differently about that than I do about a situation where, the United States government is penalizing a state actor because they know that they're sponsoring disinformation campaigns. That's a kind of deterrence I feel like I can get behind. And
yeah, that's a subject of international relations, and that squishy domain of international relations. I mean, information warfare is kind of I guess, a peaceful alternative to the old kinds of warfare. So
beats a sharp stick in the eye, literally. Okay.
We've evolved at least, so on the bright side, but yeah, absolutely. We're talking about something very different when it comes to concerted disinformation campaigns by nations. And let's be real, we all do it, including the United States. Like, we have folks in our national security infrastructure, some of them based here in Washington State, who, they will analyze like, hey, what was really popular? What words and terms were really popular right before that uprising in this jurisdiction of interest? And you know what? Can we find an association between certain kinds of stories that were going viral around the time of these uprisings? And rather than planting boots on the ground and trying to get an uprising like we did in the olden days, why don't we plant stories and get the kind of uprising that we want? And so, everybody does it, the United States included. It's just sophisticated analyses of information. What kind of rules should apply to this beyond the naked power of international relations? Goodness gracious, we're still stuck. We haven't even really updated the laws of war for our modern age and non-state actors and so forth very well. So I think we have a long way to go to systematically formalize the rules here. I think it's going to be pressure and power politics here.
So we have that's very interesting. Also, like, a good reminder, who knows what we're up to as a nation, what we're modeling. Has there been any discussion within your respective fields of regulating or holding platforms legally responsible for algorithms and other design aspects of their technology? It feels like this may be equally as important as regulating content once posted but less discussed. There's a lot of conversation, at least in my field, in Professor Fan's field too, of like privacy and information studies and algorithmic discrimination and the like, where what the conversation is about is, are these platforms accomplishing something through algorithms that happens in a way that's sort of emergent, that we would feel very uncomfortable with if they were doing it on purpose, for example, right? And so the idea is that how do things go viral? How do certain stories or certain posts or whatever happen to propagate? Well, part of that story is about algorithms. And an example I think is pretty concrete is if you watch something a little questionable on YouTube, where you're sort of like, your friend sent you this thing, it's really weird, it seems to be talking about this guy who is in government, but nobody knows who he is. And anyway, take a look at it and you watch it, the algorithm might say, you're potentially interested in this whole weird universe about this, and then show you the next video. And that video may be a little further down that rabbit hole, and further and further and further. And so you can have this concern where part of the reason that folks get radicalized or find themselves in the disinformation context is because the algorithms are nudging them along the way. And so one question might be, is that really, if we go after YouTube, if we interrogate and penalize YouTube for its algorithms nudging people down a rabbit hole, is that really the same thing as treating them as the publisher, right? Because I mean, all the 230 says is, look, we're not going to treat you, YouTube, as the person who posted this video about QAnon. We're not going to do that, right? But what about, you made a media ecosystem that causes people that show a minute interest in a subject to go further and further and further down that interest subject until they get to some really dark places. Can we penalize that? Can we talk about that, right? So that's how I would respond.
I think I'll just add one more thing to that really excellent comprehensive response, which is that I think, I interviewed technologists for my most recent book. And, I think there's real interest among technologists for guidance on design ethics. I mean, before you sanction, how about you educate, you give ethics, you give guidance, rather than just hit people without giving them guidance, I think. And so I think there's a real hunger, especially among this generation of programmers who are, they're interested in wanting to do good. They don't get much education on ethics in terms of design. And I think there's a lot of interest in that, in the tech community, technologist community.
Yeah, I mean, design really matters. I mean, that's something that we're seeing also in the commercial context where, you get nervous about these nudges and the way that these platforms are designed to keep you on there and to get you to buy things and click on things. But I agree with Professor Fan. I don't think we jump from, hey, this is problematic, to let's criminalize it, right? Or let's remove all immunity, but rather you say, how can we make sure that, how can we create better incentives for these platforms not to engage in that kind of behavior, though it's profitable? All right, so we're coming up against the hour.
Looks like we have one final question.
Final question above that I missed. Okay, yeah, go ahead, Mary.
So it says, what does the explosion of mis or disinformation mean for education? Can you speak on how we can seek to address this problem in the classroom? How can we seek to help students become better able to evaluate or interpret information as we enter a time of mis or disinformation like we've never seen before? Now, interesting question. I think, if they got into the University of Washington, frankly, they're not your average target. I mean, they're already kind of a cut above like the big mass that you're really worried about being misled. So I think of them actually as future educators too. Obviously, they're also consumers who may be misled by mis and disinformation too. But I also think that they're, frankly, and as I often tell my students, when you're here, you're already, we have grad students, so that's especially true. You're already kind of in the top, percentiles in terms of education, knowledge, etc. So really, I think in terms of this educational context, we're also training students to be equipped to and interested in trying to correct the imbalances in access to information, and to be aware of confirmation biases. I think especially in educational institutions, it's important to teach students about the danger of echo chambers, confirmation biases, to which, frankly, higher education is also susceptible. I mean, that's going to help make them better educators for the community.
Yeah, I mean, some of the things that we do in law, where, like for example, the Socratic method, and some of the techniques that we use and teach in law are meant to make people really be testing arguments for their validity. You know what I mean? And so that's something. But I'll tell you that the center has a number of different programs that are specifically dedicated to this question of and so, for example, our director has he and a colleague in biology, Carl, have a whole class and a book that's called Calling Bullshit. That's about figuring out, when people are trying to mislead you in science. We have a Misinfo Day that we've been doing at the center that has many high school students who come in to learn about misinformation and disinformation. And so, you know, our approach at the center has been one of thinking about community engagement and education as being important tools that we have in order to make people more resilient as well. So it isn't all about the law. Okay, so I think that's gonna wrap us up because we're at time. But you know, just want to say thanks again to the organizers and thanks to Professor Fan. So thanks everybody watching, and especially the alumni of the iSchool and the School of Law. We really, it's so important for you to keep connected with us, and we think of you as our students for life, forever. So thank you very much. And there will be a recording of this talk, which will include closed captions that we'll be posting in a day or so. So if you couldn't follow or if there was something that we could help. But thank you for your great questions, and thank you for listening today. We appreciate it. Bye, everybody.